Good afternoon, everyone.
Good afternoon.
Good afternoon. So, do you know I was connected to this event, a big event that had Stanbic IBTC and some other guys?
I thought everyone is on mute. Okay. Good afternoon, everyone. Welcome to this webinar. My name is Busola Ajala, and I am the founder of Strictly Law Business. This webinar is in collaboration with Wiseview Legal and Cabis and Goldborn Road Advisory. And the essence of this webinar is for us, like the topic of the webinar says, restructuring and consolidation of law firms and law practices in Nigeria. We feel the time is ripe for us to begin to have conversations around how we can deepen and strengthen law practices, in Nigeria, so that we can compete globally with we are strong enough to compete with our counterparts in the international community. And we feel that there is no better time to have this conversation than now, so that every one of us, either as solo practitioners, partners in law firms, senior associates, or whatever category we are in, we can begin to think about how we can strengthen our legal practice in Nigeria, so that we can grow our law practice, our legal industry into strong institutions. And that's the essence of this webinar. And we feel that there's no better panelists to put together for this webinar than those who we have seen, done something in line of what we are discussing about today, in line of today's conversation, people who have, who we have seen as, who have tested things and it's really working for them. So we are delighted to have with us Mrs. The Learned Sikh, Mrs. Funke Adekoya, SAN. Thank you, Ma, for accepting our invitation and for accepting to do this. Also grateful to Mr. Baba Alukolaro of the New Practice, who is also joining us as a panelist for today's conversation. And also we have Mobola Akikupe, a partner in AO2 Law. And so right about now, we have 66 participants. I just want to see if we could get more, because we have over 300 people who signed up for this conversation. And I don't know if I have the kind permission of our panelists to wait for just a few more minutes so that we can have a good number of people before we kickstart the conversation, just to ensure that we have more people in the room to do this. And also on this conversation, or moderating with me is Benga Ajala. I'm sure Benga Ajala is here with us. Please, do you want to say something? And we also have Kayode Adekola and Kingsley Ogochukwu. Benga, would you like to say one or two things before we Okay, I think we have a good number of people. We have over 72 people here now. I think we can just start, and others would just catch up with the conversation. I must also say that we are streaming this live on YouTube.
Good evening, ma.
Good evening.
It's Barrister Paul.
Barrister.
Paul.
I'm sorry, which Barrister Paul is this? Full names, please.
Barrister Paul. Sorry, I'm calling you with a different line.
Okay, what's your surname? I need to.
Paul, no.
Okay, Paul, how are you?
Fine, ma.
Okay, how's everything?
Fine, ma. I thought it's been a while. Let me greet you today.
Well, you don't greet.
Apologies for that. I've had to remove that fellow from the conversation. I'm sorry. So I think we'll just start with Mrs. Adekoya right now. And do I have your kind permission, Ma, to begin to share your slides?
Yes, please.
Thank you, ma'am. Just a minute, please.
I can share them from here if there's a problem.
Okay, ma'am. Okay, ma'am. That will be fine, ma'am.
Okay, let me just share my screen. Oh, you've disabled screen sharing, so you'll have to do it from there.
Okay, ma'am. Okay.
Okay. If you can possibly put it on slideshow, it would make it easier for us all to see what I'm speaking about. But as you can see from the title slide,
Okay, ma'am.
slideshow, and then click from start.
Okay, I'm trying to figure that out. I'm sorry.
Up at the top,
Okay.
up at the very top, you'll see view, review, slideshow, press slideshow.
Okay.
Slideshow, and then play from start.
I have, sorry, I have just share screen here.
Hey, don't worry, but then you're going to have to scroll downwards as I go through.
All right, ma'am, that's fine.
Okay, good evening, everybody, and thank you for sparing the time to listen to this afternoon's discussion. Our host has laid the foundation for what we're going to talk about. And before we get into the discussion, I just like to look at what the landscape is, because I'm looking at the legal landscape post-COVID-19. We don't even know when post-COVID-19 is going to, in faith, that we're not going to be like this forever. And that at some time we will be out of a coronavirus infected area. So I'm going to start with what is the present position today, so that we can then know what it is we're going to be looking at or looking for post-COVID. So if you can click on the second slide, the present position. Just scroll downwards, yeah. Yeah, the second, and then click on that. No, the one above. Yeah. So where are we today? Presently, the profession is organized into three. You have sole practitioners who work for themselves. Then you have, I would say, associations of lawyers who work in what I would call chambers. And they have various different types of arrangements between themselves. And then we have law firms. I have categorized the difference between chambers and law firms from a management perspective. In other countries, that categorization would be from a practice perspective. People tend to speak of chambers where lawyers go to court. They are actually barristers, and they are all self-employed within a chambers structure. And law firms are basically organizations of solicitors who do not go to court unless in the UK you have rights of higher audience. I'm not looking at it from that perspective. I'm looking at chambers from the perspective of different types of relationships, and I'll talk about those relationships in a minute, as opposed to what I call law firms, which are, irrespective of their size, are more structured in terms of the relationship between the lawyer who is employed and the owners of the law firm. So if we go to the next slide, we'll then look at lawyers as owners. So could you just scroll down and click the next slide, please?
Okay, ma'am.
So today what we have is we have lawyers as owners. And you're an owner, whether you're a sole practitioner working for yourself or you're a law firm partner, or possibly if you're the owner of the chambers. As an owner, whether you're a partner in a law firm or you're a sole practitioner, you are solely responsible for generating your income. You do all the work yourself and you make all the money. That's if you're a sole practitioner. If you are a law firm partner, you have responsibility for generating that income. You may not do all the work yourself because you would have associates to work with you. And obviously you would have to remunerate them. So the money that is made does not belong or will not be utilized only by the law firm owner or the chamber's owner. However, as the owner of the business, sole practitioner, head of the owner of the chambers, the owner of the law firm, you are solely responsible to pay the rent. It's your responsibility to pay the utilities. It's your responsibility to pay the support staff. By support staff, I exclude the lawyers who work in the firm or the chambers. I'm talking about secretaries, litigation clerks, regular clerks, maybe there's a driver, a cleaner. So let's start from the point of view of law firm partner, chambers owner, sole practitioner, responsibility for generating income solely, responsibility for paying expenses solely. And contrast that now with the next slide where we look at lawyers in employment. So if you can click on the next slide. Lawyers in employment. Now, if you are in employment, you could be in employment in a firm of chambers, or you could be in employment in a law firm. The difference I have identified is that in a law firm, there's likely to be some sort of a structure. You are more likely to have a contract of employment, which sets out your rights and your responsibilities, the relationship between the firm that employs you and yourself, your expectations, your entitlements. In terms of a chambers, you would probably find out that there are different remuneration structures. You might be paid a salary, but you do not work. And that, hello? Okay, and that then brings the chambers more in line with a law firm structure. But you find out that in some chambers, there are different remuneration structures. You may be paid on a per brief basis, which means that yes, you are employed, but you are paid piecemeal. So you work on a brief, you are paid either a percentage of the fees from that brief, or you are paid per appearance. In some parts of the country, you are paid what's called a transport fee each time you go to court, or an appearance fee. So the difference is that if you are in employment, you earn your source of income is regulated in some format, depending on if you're in the chambers or in the law firm. Somebody pays you. You have no responsibility whatsoever for overheads. So whether, as they say in the southwestern part of the country, whether the boss earns money or not, the remuneration of the person who is going to carry the load is intact. So that's the difference between if you're an employment, you generally have no responsibility for paying any of the overheads, but the form of your income is regulated based on the type of employment structure you have. Now let's look at what I think is going to happen post-COVID. Go to the next slide and click on it, please. This is my speculation as to what the legal landscape is going to look like post-COVID. All of us now are sitting at home, and even where we are going to work, hours are reduced. And therefore there is pressure both from lawyers, from everybody, for money. The result of that, to my mind, is that clients are going to want lawyers to do more, but because they do not have the funds, they are willing to pay less. So you'll find out that whereas perhaps previously you could do an incorporation for 50,000, a client will now want an incorporation and he will say, can you do it for 30,000? Or a client has a tenancy matter and he's going to say, well, initially he would say, okay, I'll pay you 100,000 to conclude from beginning to end. And now he's going to say, I'll pay you an appearance fee each time you go to court. I'll pay 5,000. Or I can't pay 100,000, I'm going to pay 70. And because lawyers themselves are pressured by the same economic downturn that has pressured the clients, there's going to be an increased competition for legal work among lawyers. And therefore, lawyers are more likely to want to negotiate their fees unless it is extremely high value, skilled, one-of-a-kind litigation or drafting. So the whole economy is under pressure. Lawyers are also under pressure. There's going to be increased competition for legal work. What does that mean? If the income that's coming in is decreased, then there's going to be an increased financial pressure to cover your overheads. We must remember that law is a business, and therefore we're practicing a profession, but we're hoping to practice it for profit, which means that your income should exceed your overheads, and the difference between the two is your profit. If your income comes down, there's pressure to cover the overheads. So either your overheads come down so that you have some profit, or you're going to be in debt. The other thing to take note of from where I sit is that there's going to be delayed payment of lawyers' invoices post-COVID. And this is the same reason that we started. There's pressure on the clients. They themselves have not made as much money, or they see a position where they would not have made as much money as they had budgeted for at the beginning of the year. Unfortunately, lawyers provide a service that no one really sees. And so the result of that is that what you don't see, you don't value. You're sick, you go to the hospital, the client will pay the doctor's fees because he can see the doctor bringing out his instruments and providing medicine. The doctor pays an accountant's fees because he can see the statement of accounts which he needs for his tax clearance. But you can't really see what the lawyer's product is, especially where the lawyer is a barrister or an advocate and goes to court. So there's going to be delayed pressure, delayed payment for lawyers' invoices. And so what's going to happen? If we look at what is happening abroad, law firms abroad are doing all sorts of things to maintain themselves in existence until COVID is over. Some have laid off some of their younger associates. Some have laid off some of their older associates. Some have done salary cuts. Some have put people on furlough schemes. But at the end of the day, my prediction is that the post-COVID-19 legal landscape will be different from what it is or what it was in December last year. The clients will want more work for less money, and there will be a contraction in the legal services industry, which might result in either chambers or law firms laying off staff. So in light of that, and in the context of the discussion which brought this webinar about, let's look at what the advantages are of changing your business model. Can we go to the next slide? Please press the next slide. Now, should we restructure our businesses? Should we merge them to make larger law firms? What are the disadvantages of changing your business model? Could you go up first? I'd like to speak of the advantages before I go to the disadvantages. Yeah. So what are the advantages first of changing your business model? So you're a sole practitioner. What are the advantages of moving to a law firm? And by law firm, I mean a partnership structure, because most law firms are partnerships. The first thing is that you're sharing the responsibility for generating income with someone else. Two heads are better than one. And this is an instance in which probably 3 or 4 is better than 1 as well. You're also sharing with someone the opportunity of bearing your overhead costs. So if your annual rent was 400,000 per annum and you had to pay it alone, if you form a partnership of 3 or 4, each person has to contribute 100,000 to the cost of the rent. So less of a burden. Another advantage is the ability to afford more because your costs are shared. So if you alone were bearing those costs, you might say, I can't afford to pay for office space more than 400,000. But if you have 3 or 4 partners, you could say, well, fine, if each partner can put down 150,000, we can get a larger office, which we'll need anyway, and we can put down 600,000. So because you're shifting or sharing the costs, you can probably afford more. And then another advantage, your clients are supported. You can afford to take a break. If you go on vacation, you can have a peace of mind because you know that the work continues even when you're not there. If you fall ill, you don't have to rush to get back into the office because you know that a partner will fill in the gap when you're not there, will keep the office running. And finally, and possibly most importantly of all, depending on how you structure the partnership, you've got access to knowledge that you yourself didn't have, access to skills that you yourself didn't have, and a wider network for promoting the services that you want to sell. So it looks as if definitely there are distinct advantages to changing your business model post-COVID and looking at moving from being a sole practitioner to a larger firm, either by merging or consolidating or having some other form of a relationship. But if you're looking at sole proprietorship to partnership, there are disadvantages. And I need to let you know what those disadvantages are, speaking as a partner in a law firm. So let's go to the next slide. So what are the disadvantages of changing your business model? And I apologize for the spelling mistake in the word disadvantages. The first and the most important that we need to consider if you are considering changing is the loss of autonomy. It is real. It is something you need to think about and decide whether it is something that you can live with. You lose your autonomy. You give up control over use of your time and your money. And this is because once you form a partnership, your time is no longer yours. Your time now belongs to the partnership, depending on the terms of the partnership deed that you have drawn up. Your money is no longer yours because you have obligations to the partnership. And when the income of the partnership comes, it will be shared according to as you have agreed. So profits must be shared. So that 1 million naira brief is no longer yours for you to do exactly what you feel like. It now has to be shared among the partners, irrespective of who did the work, depending again on the terms of the partnership. And then you have unlimited liability for partnership debts. That's the partnership law. And therefore you need to choose who your partners are going to be very carefully, and have a well-written partnership deed. I think I will stop at that point. I've laid the foundation for things you need to consider if you want to think of restructuring post-COVID. All I will say is that there are benefits to being a sole practitioner. There are also benefits to being part of a larger structure. Thank you. So I'm done.
Okay, thank you so much, Ma. We are grateful for that insightful presentation. And I think we'll go over to Mr. Alokolaro now to have him speak to us on the topic.
Thank you very much. And I note that there are quite a number of practitioners that I know in person that are also on this webinar. I say hello to everyone. Basically, I'm just going to speak about, I'll take us through a bit of history, legal practice in Nigeria, and I'll go through a few cycles. When the practice of law became fashionable in the country, we had a number of sole practitioners and law firms that were partnerships created then, largely around personalities and reputation. There were a few firms early in the, maybe in the early 1930s, 1940s, with established, I'll say big names that went into partnerships that sooner rather than later split up, again, across reputation and individualism and the characters. Now, they largely practiced as barristers in the country because then it was more fashionable to be a barrister. In fact, I don't think you were counted much as a lawyer if you were not a barrister and appearing in court. Fast forward a few years later, perhaps to the 60s, when personalities like my father started to practice law, then you had more sole practitioners as fashionable enterprises in the practice of law. And again, these guys practice law more on the basis of the reputation of the lawyer. And they were able to attract business largely because of the reputation that the lawyer had created in the marketplace. And began the, you could have a Femi Alokolaro and Co., Yomi Oshikoya and Co., to call a few names. And you had bigger firms like Chief Rotimi Williams Chambers, Gani Faremi's Chambers, GOK Ajayi, H.O. Lardner's Chambers, Chris Okumbanjo and Co. And these firms were largely built, again, I say, around the individual who created them. And most of these firms grew as firms with, what will I say, the resource persons behind them being either employees or members of their families getting into partnerships with them. If you fast forward from the 60s to the 80s or early 90s, a bunch of lawyers realized that the models from the 30s, the 50s and 60s and the 80s needed to be improved upon, perhaps borrowing from what was more fashionable in the Western world, Europe, the USA, England specifically. And the concept of creating successful partnerships evolved. You had partnerships like Odujiri and Adefulu, which was created and is still in existence till date. And you had fresh partnerships with brilliant young lawyers establishing a footprint in the legal marketplace, like Udo Udoma Bello Osage, Banwani Godalo, Alukwano Ibode, and so on and so forth. And that's probably late 80s, early 90s. And they created a platform where, looking at perhaps the mistakes and challenges that the previous business models had in growing their businesses, realized that there was a need to open up beyond familial areas. So let's not just think of our family members and people that we know and the ones that we think that we trust, but on the basis of trust, actually call a few intelligent people across service areas, across subject-specific specialty areas, and sign a partnership deed and grow business and actually practice the business of law. A number of these law firms are still existent today and have grown significantly. And you had some that also went into partnership and were unsuccessful with the concept of growing a business as a partnership. Perhaps they had issues, either it was a matter of emotional intelligence, egos came to work, trust issues were also fundamental, not accepting that a partnership with one or two other people was in essence a marriage to that person. And like any marriage, it can be successful and it may be unsuccessful. You may end up in a divorce, you may end up in separation, or you can remain happily married forever after. And of course, you then had a next generation of lawyers, like I'll say, I'll use an example, and I'm mentioning names now, like Templars, for instance, then came into existence, I believe either it was mid-90s, that also saw a gap in the legal marketplace of what could be done, and generationally decided to do a service to their generation. And then you have the likes of partnerships like my partnership and a bunch of others. I see one of the practice administrators of one of my good friend partnerships. She's actually on this webinar. She may not know that I noticed, but I saw her name, that she's watching. Why is she watching? Because the business of law goes beyond what we, the lawyers, do on a daily basis. As it is a business, you need to look at the numbers. And as you look at the numbers, you need to make sure that in your success plan, you have a succession plan. You have a business continuity plan. You have a disaster management plan. None of us envisaged that we were going to see a COVID-19. And if we ever thought of one, we never thought it was going to be this bad that we need to start rethinking how we practice law. What presently portends for the business that we all individually engage in? There are some realities. Globalization. We cannot continue to ignore that the globalization of law practice is going to come to this country. It's at our doorstep. The large law firms used to fly in pre-COVID into this country on a weekly basis to take food off our tables. So at some point, some of us have to grow big enough to be able to go into some kind of consolidation move with these guys. Either they acquire us, if we're able to raise financing good enough, perhaps we may be able to acquire them, in reverse. We decide that we consolidate. Perhaps I sit at the table with the ALEX partners and say, look, I'm a small fish, you're bigger than I am. I have certain skills and specialties that you may wish to consider. When the likes of Clifford Chance, Allen and Overy, and so what and so forth decide to come to Nigeria to say, this is who we want to do business with, then perhaps we could look at opening up and going to some kind of consolidation move. But this, I'll say, were conversations that most practitioners were thinking about pre-COVID. The future then, we thought, was that globalization was coming. But COVID has taught us something. Beyond globalization, we're going to end up, and I'll go to regulation in a bit, we're going to end up highly leveraging on technology for the future. What the future says is that we all need to specialize. We need to specialize in different areas with our skill sets and leveraging on those skill sets to deliver value to our clients. Our clients are definitely going to come down on us in terms of our billing. They don't want to pay and they want value. I was talking to my partner the other day about a bill he had just negotiated with the client and needed to put on record because now we are in COVID. And I said, look, the problem with the guy is he doesn't see value in what we've given. Now, are regulations fit for purpose? No, they're not. These regulations were built several years ago, way before I was born. And these regulations tell me who I can and cannot share profits with. In today's modern age, surely, I mean, I followed the American example when I decided to set up my constitution. I followed the UK example when I decided to bring up certain laws. I'm even following the Singaporean example in enacting present day law. So please tell me, why am I still using legislation and regulation from the 60s to regulate how I practice law as a business? Why can't I open up my business for investment from investment banks or whatnot? with a view to sharing profit or with a view to raising capital such that I can approach any of the big law firms and say today, Mr. Irokosu, please come, let's join our partnership, raise some money, and make them an offer that they may not be able to refuse. They take the paychecks and go into retirement. We decide whether we're changing the name of the firm or not. And then we then say, well, this is the future. But today's future coming post COVID-19 is such that we're going to have virtual law. Virtual law is going to be real. Overheads are there. I mean, we almost made an investment mistake pre-COVID, and my partners and I laugh about it today. This is not a time for going into not well thought out investment or expenditure. This is the time to consolidate. This is the time to collaborate. This is the time that when you look at the future, you need to reduce your costs significantly with a view to being, one, with a view to subsisting and surviving first before we start looking at profits. We've done a model for the rest of the year and we know how much it's going to cost us just to survive as a business. When we had our retreat late 2019, early 2020, we had fantastic projections of where the money was going to come from. But reality is, we're not sure where that money is going to come from anymore. Can I just let my people go? Surely I can. But these guys have invested their time, their skill, their effort, their lives into the business that we run together. So at a minimum, their welfare is also important. How are they going to work? Must I demand that they are in the office on a daily basis? We are working a scheme right now where we have 1 week in and 1 week off, using 2 different teams. There's a team A and a team B led by separate partners. We're still trying it out. So there's a lot of stuff that we're going to keep trying out as business owners and business operators, law business operators, that we will ultimately find a solution to how we can survive and subsist as a business in the practice of law. So post-COVID, consolidation and restructuring of law firms is an absolute certainty. Will we have brick and mortar law firms with massive offices with 200 lawyers? I'm unsure. Will we keep it lean and mean and tight and reduce our costs and expenditure? That's an absolute certainty. So ladies and gentlemen, all I can say to you is that the future is coming. The future is going to largely depend on technology. The future is going to see the springing up of a number of virtual law firms. And most technology lawyers nowadays don't even want to work in a traditional law firm anyway. And that is one area that is going to continue to be profitable. Look at, we're all on Zoom. The profitability and market capitalization of Zoom skyrocketed in the twinkling of an eye. So let's borrow a leaf from the rest of the world. Let's borrow a leaf from the rest of business. And let's find how we continue to make and sustain our individual businesses. Thank you very much.
Thank you so much, sir, for that brilliant presentation. I'm sure there are a few takeaways, and I'm sure that we'll have questions when it's time for the Q&A. So we'll go over now to Mobola to speak to the topic of today's conversation. Thank you, Mobola.
Thanks. Good afternoon, everyone. I'd like to start by thanking the organizers of this event for inviting me to speak on this panel. I'm particularly honored to be speaking along with very senior colleagues, Mrs. Funke Adekoya Essien and Mr. Arokolaro. I'm also very happy to be sharing my experience with the panelists, and I hope that they will take a thing or two from this webinar. I'll just go on to, I'm just going to tell my own story to merger. I worked with Dr. Olawang, and I would like to refer him as an absolutely brilliant lawyer. I think it was at that point I realized that I wanted to practice law, really. And of course, I worked there for about 2 years, and I decided at some point that it was time to move on. I mean, at that point, I hadn't realized if I hadn't decided if I wanted to move on to another law firm or actually set up my practice, but I definitely knew that this was the path that I wanted to toe. I mean, I eventually came up with a decision. I set up practice, and my vision at the time was to deliver excellent services to my clients. I was in partnership at the beginning of that law firm. It was called Octus Legal. But fortunately, that partnership didn't work. But of course, I continued in practice, and I was a sole practitioner for another 3.5 years or thereabout. I mean, the foundation of everything I did was the vision that I had, which was that I wanted to deliver excellent services to my clients. And so I knew that structures and systems and processes needed to be in place. And I wanted a business that, wouldn't just be about me, really. So I knew that sooner than later, the option of going into partnership, some form of consolidation will have to come into play. Of course, I started praying about it because I had been involved in a partnership that didn't work. So it happened that, I got offers, and I also actually reached out to people who I thought I could partner with. I mean, I had conversations with several people, and I eventually found out that, I eventually just decided that the law firm that I currently am a partner at was best for the vision that I had. So, we were in discussions for over a year, and of course, there was a lot of due diligence, and it's been a year now that we merged. But what I would like to say is that I feel like in restructuring or consolidating, I think it starts with what you personally want to achieve. You need to look at what you want to achieve out of your business, also what you want to achieve out of your brand or your career as a person, before you then decide what steps you want to take. There's no gainsaying that we find ourselves in unprecedented times as a result of the pandemic, and the world will need to readjust. And the legal industry is definitely not an exception to this. So we need to start to be forward thinking about how we want to run our practices and the things we need to do. If there are things that we feel like we need to do, of course, we're here on Zoom, and I feel like this is the new world order. We're going to have to up our game in terms of technology. There's going to be a lot of artificial intelligence, so we need to be forward thinking in this regard. But restructuring is definitely something law firms need to look at, because if we look at the economies of the world which we service, who are restructuring, we will need to follow suit on the idea of restructuring. So I feel like the first two speakers had laid a perfect foundation. So I wouldn't want to take too much time. I'll just stop there. Thank you.
Okay, thank you so much for that presentation. I think we'll just go into the question and answer segment. I don't know if there are participants with questions in the chat room. Please just give me a second to find out the questions we have here. Okay, I'm not sure there's any particular question here, but so we have a question from Mrs. Adekoya, and we'll just go straight into the question for ma'am. So the question for Mrs. Adekoya is this: can everyone hear me? I assume everyone can hear me. Ma'am,
Yes,
can you? Okay, ma'am. So I was going to ask that before going into the partnership or consolidation with Alex, right? You were already doing very well as Funke, Adekoya, and Co. And at the time, you were even concerned with the status of senior advocates of Nigeria. But what do you think was missing? And what do you think was missing that led you into the consolidation? And would you say as of today that missing?
Sorry, I lost the last part of your question.
Okay. So I said you were, okay, so I'll start again. I said you were doing well as Funke, Adekoya, and Co. and you were already confirmed with the status of a senior advocate of Nigeria. So what was missing? Was there any missing link? What was missing? What necessitated the move for a consolidation, or or the move to go into partnership with other people that's brought about LX and so? What do you think? And do you think that that's missing? Would you say that that missing link has been filled right about now?
I would say, let me start from the end, which is, yes, the missing link has been filled. But let me go back to the beginning. The first thing is that we started talking about a merger of law practices in 1999, before I became a senior advocate in 2001. And it took us 5 years to work out where we wanted to be. So it's something that you're not, I don't advise anybody rushing into. At the end of the day, it was not all of us who started the discussion of forming a mega law firm that would compete with the international law firms that were traveling into Nigeria. As Baba Olukolaro had mentioned, it's not all of us who are sitting around the table that ended up with ALEX. ALEX is the merger of 4 law firms. When we started the discussion, I think we were 9 or 10. But did I get to where I wanted to be? Why, after I became a senior advocate, did I continue with those discussions? I continued with the discussions for the simple reason why we started the discussions in the first place. All of us wanted something more. We wanted all to practice at the level of the international law firms. I, for one, wanted the ability to conduct dispute resolution, whether it's litigation or arbitration, at the level of those international law firms and pitch to the clients that those international law firms were pitching to. And therefore, it became important to ensure that at the end of the day, that mission was achieved. In trying to achieve our respective missions, some law firms dropped out, some we didn't agree on various things. But has it been worth it? And have I achieved my objective? Yes, I have achieved my objective. I practice now on an international level, whether it's litigation or arbitration. I have more international clients, and that's what I wanted to do.
Okay, ma'am. So the next question will be, there are a lot of politics that comes with managing a large enterprise. And how would you say you've been able to deal very well with those politics? And how do you deal with this, especially as it concerns promotion and admission into the management cadre?
I think the first thing is that right at inception, if you decide to consolidate or to merge or to build a large law firm, the first thing is to get it right in terms of everybody's responsibilities. You can't make it up as you go along. If you have a partnership deed that covers every scenario, including issues as to promotion, as to new partners, as to responsibility for decisions, resolutions, majorities, super majorities, unanimous consensus, then there's nothing new under the sun. So we did not, for instance, we didn't write a partnership deed out of our heads. We actually went to the Law Society of England, took out their model law firm partnership agreement, read it through from beginning to end, and adapted it to what we needed. And it covers every scenario. So you find out that, yes, you may not agree in terms of promotions and elevations, but once you stick to the terms of the deed, you are covered. You can't have your way all the time. As I said when I started, the first thing you must accept is a loss of autonomy. So sometimes when I was the managing partner for the first 4 years of the partnership, there were times when I felt very strongly that the decision taken was not the right decision. But because we're now a partnership, we go by the terms of the deed. If it needed a unanimous decision and it wasn't unanimous, so be it. Sometimes I had the opportunity to go back and say, I told you people so. Sometimes we were able to rescue things as we went along. You need to get it right. Everybody needs to be on the same page, as Baba Lokolaro said when he spoke. You need to know that you're not just practicing a profession, it's a business, and you have to run it as a business. As a result of that, in 2 years' time, I'll be retiring from Alex.
Wow.
I'll join you in the unemployment market, or I'll join someone in the unemployment market.
Okay. So another person is asking you, ma'am, that where a member of a law firm is invited to the partnership board, is it always necessary for the new partner to subscribe to an existing partnership deed and the deed to be refilled? And should the deed be refilled with the Corporate Affairs Commission?
Yes, it is. It is advisable for new partners to have a deed of adherence. And it is advisable to have that deed filed. But even if you don't, you need to have a deed of adherence.
Okay. So somebody is asking, we'll go to Mr. Baba Lokolaro. He says, what advice will you give to a lawyer who wants to start his or her own law practice, but does not have any clients? Can you advise on how to build clientele? This is against the background that this lawyer has a post 10-year call to bar working experience. How should the person start looking for partners to collaborate with also?
Finding a partner is more or less like finding a spouse. So you don't just pick up somebody from the streets and say, I'm going to marry you. You're going to date. You will argue. You will resolve those issues. Then you decide, okay, I love you. How about we have an engagement? Engagement works out. You know what? Let's marry. Let's go before the altar and decide that we're tying the knot. You tie the knot. There's a huge risk to it because you've just signed up for a forever with this person. And hopefully it works out. Now, you would know the character of the person that you're going into partnership with. A partnership deed is nothing more than a sheet of paper that you've just written on. It regulates the affairs of the business, but it doesn't guide who the characters are. So the personality types of who you're also going into partnership with is critical. You must know the sort of person that you've decided to go into this relationship with. Integrity is a critical factor. So is trust. So if you have these issues, you can tick those boxes. Then of course, I'd say to you that it's good to date first and don't just jump, all in at once.
Can I jump in?
Yes, ma'am.
There's a question that had been asked, and I had said that I was going to answer online, and it feeds exactly into what Baba Lokolaro has just said, and that is the key considerations for a partner. It depends on the individual and what you consider to be key. If you are very strong on ethics, you obviously do not want to get into a partnership with a lawyer who has no compunctions about giving 10% to get briefs. It's not going to last. So for me, the key considerations, or at least for our firm, the key considerations for starting the partnership were value. What is each, at the time of the merger, what was each merging firm bringing to the table? What were our ethics, and what were our expectations in terms of the type of law practice we want? In terms of ongoing new partners joining us, we look at three things as key considerations: your ability to do the work, your ability to mentor the younger associates, and your ability to administer or run a law firm. Could be in different percentages, but you need to be able to tick those boxes.
Would that be Homer?
Yes, I believe I've answered the question of key considerations.
Okay, thank you, Ma. So the next question is goes to Mobola, and so how do partners deal with fallouts with other partners, which may lead to some partners making an exit? So how can how do we deal with fallouts with other partners?
Okay, thank you very much, Busala. I'll again make reference to my experience. It was tough because I felt like, I felt betrayed in some way. It took me time, but I was focused on what I wanted to achieve. I think it will differ from person to person, really, how you deal with fallouts. I mean, I don't know if I've answered that question.
Can you share with us your own experience of how you dealt with the fallouts?
I mean, I just moved on because life had to go on. So I moved on and I continued the practice. I mean, I knew that this was what I wanted to do. So nobody was going to deter me. I just continued from where I stopped. So some people like to feel like when there is when a partnership does not work, it ends. And I say to people that no, you just continue from where you stopped. So I just continued. I didn't look back. I didn't pay mind to anything or anybody. And this was how I moved on. I mean, I'm going to also make reference to prayer a lot. I prayed about it because I will not deny the fact that I felt hurt and it took me time to get over it. But yeah.
So again, I would also want to ask that, so you moved on, but then were there issues of finances, financials that you had to deal with, that you had to perhaps maybe split or maybe, get from the partnership before moving on? How did you deal with the finances?
Okay, thank you for putting more context to that question. We had an understanding, and so we just went with the understanding that we had. I mean, so if you have a partnership agreement, that will form the basis of any partnership and dissolutions thereof. So, I mean, that would be the only way to go about it. You would go by your partnership agreement or anything that governs the partnership, which is what we did.
Okay, thank you. So
can I add something? I just want to add something. Again, from a historical perspective, I don't know how many people on the webinar actually are aware that Aluko Body was actually part of a partnership called Ajumogobia Okeke Aluko Body. Somewhere along the lines, they decided to disengage and split the partnership along two lines. Ajumogobia and Okeke went in one direction, Aluko Body went in another direction. The initials of all the four partners were also similar. So in essence, the marketplace had two A and O's. And at some point, if you worked in one or the other, they would ask which A and O. The letterheads were the same, as a matter of fact. Their font type was the same. The font size and all their written material was the same for a number of years. Now, obviously, that may have been as a result of what was contained in the partnership deed, but they continue to mutually exist and be successful businesses till today.
Can I add on to that as well?
Okay. So,
yes, please.
Baba mentioned Odujiri and Adefudu, and forgot to mention that Adesoya and Ayolaja also joined and became partners. The firm name changed, became Odujiri, Adefudu, Ayolaja, and Adesoya. And later on, they two hived into two. And today you have Odujiri and Adefudu, and you have Ayolaja and Adesoya, and both of them are coexisting. So and I should also mention that from the inception of ALEX, we've had one partner who left. Everything was written down as to how you exit, how you leave. And therefore, there were no ripples when one partner left. ALEX continued. Having said that, I agree with Baba as well that getting into a partnership is just like getting married. I sometimes joke that I had, at the inception of the partnership, I had 4 husbands. So you feel it when one husband leaves.
Thank you, ma'am. So we have a question for Mr. Lokolaro here. He says, from a practical standpoint in negotiating a merger of law firms, would legal traditions, for instance, seniority at the bar, pose challenges in terms of roles and responsibilities in the new firms? What other peculiar factors should be considered?
So I'll give an illustration. A few years ago, we were approached by a law firm with, I guess, more senior counsel. They had a couple of silks, and it seemed very attractive proposition for us to consolidate. And we engaged in conversations about the consolidation between both firms. One of the first things I came back to tell my crew in the office was, look, we're having consolidation talks. Everybody needs to shape up and know that you're an expert in your space and you're at the level at which you ought to be in terms of the delivery of your deliverables and the level at which you are. Because should we go into this consolidation, we would have an objective and transparent system of evaluating who would be where. Not necessarily by year of call, because for us in particular as a firm, it's not your year of call that is most important to us. It's the level of experience you have and the expertise that you have established. So, and again, we had consolidation talks twice after that. And I'll say to you that for every lawyer, it usually is your experience, the value you're going to add, the level of expertise that you have, the level at which you are in your career, and what you're able to bring to the table at any given time. And that's what's going to be part of the negotiations. The founders or the management of the firm will negotiate terms for the benefit of the business, not necessarily looking at the input of the resources being the human capital going in. And to even negotiate on that basis, it must be on the basis that I'm bringing you some fantastic experts in different subject area expertise levels.
Can I just add to that and give you my personal experience? When we negotiated our merger, irrespective of the fact that I was then a silk, all of us who came in were equal partners. We all put down, we decided we were actually going to dissolve our old practices, and everybody put down the same amount of money to start off ALEX on an equal level. It depends on what you negotiate.
Thank you, ma'am. So somebody is also asking, this question goes to Mobola. The person says, I just wonder why the school system is still worn out as emerging courses are not being integrated into the school system, such as technology, law, sports, entertainment. And so what can be done to remedy this? As the world is evolving, the students do not want to be left out.
I'm sorry, can you take that question again? Sorry, you were breaking at some point.
Okay, the question says, I just wonder why the school system is still worn out as emerging courses are not being inculcated into the school system, such as technology, sports, and entertainment law. What do you think can be done to remedy this? As the world is evolving, we students do not want to be left out. I think we have some students here.
I mean, what I would say is if your syllabus does not cover your area of interest, then you would need to do your personal development and read up on these areas of interest so that, I mean, I know we have sports law and we have tech and all these things so that you can just blend in when you then get into practice, because there's really not much you can do about a syllabus that, you do not have. So I would say that there comes in personal development. You'd have to pick these things up, read them up, and just get past in these areas where you have a passion for. Thank you.
Thank you.
If I may add to that, I think outside of school, depending on where your interest is, and I can actually use a practical example here. I like to call people out when I come into events such as this. A very good friend of mine from law school wanted to practice as an energy lawyer. His chief interest was oil and gas law. And as such, when he was going to do his attachment, he ensured that he went into a firm that practiced oil and gas law and were really big in oil and gas law. Moving on from that firm, I know he went off to do his master's. And when he went to do his postgraduate education, he also went to study and delve further into oil and gas law. He moved on and came back to Nigeria and then went into another big energy practice. And as such, he built and developed not just interest, but expertise in that area. And today, as one of my colleagues, I'll say he's one of the best oil and gas lawyers in the country. His name is Dayo Kusami, and he's on this webinar.
Thank you very much. We have a question for you here, Mr. Alokolaro. He says, can you say a little more about how law firms should leverage on technology for future survival, both in terms of managing internal processes, but also in delivering their legal services?
That's from Nankunda. Nankunda is a tech person, so she wanted us to address technology. But as I said earlier, the future is technology. Artificial intelligence has come and is come here to stay. Technology is what we're all going to individually and collectively use to efficiently and effectively deliver our services. It will help us in reducing cost. It will help us with getting our internal processes right. It will help us in reducing the amount of time that we spend on a bunch of things that we normally do. During this COVID lockdown period, I remember I spoke to my practice administrator when we were going to lock down the office. I hope, for heaven's sake, that we have all the administrative files in the cloud somewhere, because I don't know if you think you can be coming back and forth to this office. So we're going to leverage on cloud technology. We're going to leverage on tech, even as far as, I believe, even the litigators. At some point right now, we've got practice directions that say you can have virtual hearings. They're questioning the constitutionality of that. So truly, regulations also got to change. Whether you need to wear your wig and gown into these virtual hearings, another concern, which I think we really shouldn't be concerned about. But honestly, our kids are going to school right now virtually. The parents they're running crazy. The parents, having to supervise these kids are going crazy, having to homeschool and virtual school the children. But the reality is a lot of things are going to be done virtually. Technology is the way to go. If you don't know it and you haven't learned it, you've got to have it now. It's the future.
Okay, still staying with you, Mr. Alokolaro. Somebody is asking, what would you say motivated the acquisition of Adebiyi Tax and the collaboration with Anderson Tax? What are those peculiar issues that a firm looking in this direction should take note of?
So, two different things. So we have the collaboration with Anderson Global and Anderson Tax, which is a network of what I'll call multidisciplinary experts across the world. One of the things that has done for us is it's given us a global reach. Now, for a firm like mine, which is small, our resources are also limited, and so was our reach. Now, we were spotted, well, first, grace, and secondly, because of the quality of work that we had delivered over time, and engaged by Anderson Global to say, look, we're trying to put footprints, and they're spreading footprints across Africa like crazy. We're trying to spread our footprints and bring the footprints into Nigeria. We've identified you along with a few other firms. Let's see if there's a fit, if there's alignment, and if you're one of the firms that engages in best practices as we do, and let's look at collaborating. Now, we did that, and we're in that system right now, along with, I think, about 5,000 or thereabout plus professionals in the network, or not even the network, as collaborating and partnering firms with Anderson. And as such, it's given us a foothold across the rest of Africa, where our clients, if they need any work done, I just need to call a colleague to say, look, Frank, my client is looking to do this, please help out. And in the same vein, we also have resources in terms of knowledge base and subject area. So where we're looking at doing something that is novel in any field or any area that we may not necessarily have done in Nigeria, the resource base is so wide that we're able to give our clients additional value from there. With Adebi Tax and Legal, the acquisition, tax law and specifically tax litigation was the subject area that we wanted to grab hold of, because one, the Nigerian regulator and the Nigerian government was getting super aggressive on tax. And without a shadow of doubt, we know that businesses, whether thriving or facing challenges, would ultimately, knowing their rights, challenge the right of the regulator and the taxman to demand tax from them. So in building the quality of service that we give to our clients, we felt it was a subject area with the necessary experts that we needed to build on, and perhaps we could not grow organically. So we wrote a check and acquired ATL. And of course, we also then, brought in another partner for another subject area, which is intellectual property from one of the bigger firms.
Thank you, sir. So I'll go over to Mrs. Adekoya. Someone is asking, they said, can you throw light on how to deal with capital contribution issues, how to treat assets and liabilities in law firm mergers? And the second, it's a 3-in-1 question. The second one says, apart from the motivation to merge, what are the most significant moments during this process?
Okay, let me start with capital contributions and valuation of assets and liabilities. As I said at the beginning, we decided there was no point reinventing the wheel. Once we decided that we were going to merge, there's a lot of material that's out there as to how to do it. And we got that material, we read it, we looked at best practices. We merged at a time when there were a lot of law firm mergers going on abroad. And so basically, we just valued each of the assets of the merging law firms, decided what we were bringing into ALEX. I think I still have books that are on our account balance sheets that I haven't yet been paid for, but it's there. And so we might have 3 copies of a particular law report. It's been, once we've accepted that it's being brought into the new firm, there's a value. So the accountants made a fair amount of money out of each of the merging firms. But at the end of the day, I think we were all happy. It was very transparently done. It wasn't a question of my firm is worth. We also valued work in progress. Work we were doing for which we hadn't been paid or for which some amount had been paid. We decided what the cutoff date would be as to, okay, fine, the income that comes in for the work you've done up to this date is your personal income. After that, the income belongs to the new entity. So I think we went by the book. It was much easier. We didn't have any previous precedents to look at within the Nigerian legal space. So we went by the book. In terms of what moments, I can't remember what the second question was.
Okay, the second question says, apart from the motivation to merge, what are the most significant moments during the process?
During the process, first of all, and I think as Baba said at the beginning, emotional intelligence is key. You have to take a decision as to why you are merging. It's an engagement. It's a dating process. Do I like how you behave? People are always surprised if I say that ALEX has been in existence for 16 years. At least, I don't know about the younger partners, but the founding partners, we don't go to each other's houses. It's business. If you're having a party and you invite me, I will come. If you are sick, I will visit. Otherwise, we meet in the office. After that, we go home. I have a partner, we live in the same estate. I don't think I've been to his house more than 3 times. And I think once he was having a party, once he was unwell, can't remember what the 3rd occasion was. So it depends on how you structure it. You must all agree on why are you doing it? which brings me to something, a question that someone had asked online. I think I had answered it, but I'd like to say it openly to everyone. And the question was, what do you do when you have two partners who are rainmakers and you have other partners who are not making rain? Why did you make them partners? There must have been a reason. I'm assuming that they became partners for a reason, not just because, oh, we went to law school together, he's my good friend. So either he's a partner because he's good at managing the firm, or he's a partner because he's good at mentoring the younger ones, or he's a partner because he knows how to go and sit in somebody's office and collect money. But there must be a reason why you become a partner. For us, in addition to having those technical skills. And then if you have the technical skills, we'll try and train you to become a rainmaker. So that's me.
Okay, so at this junction, I would hand over to Benga Ajala.
I think I've answered the question.
Yes, ma'am. Yes, ma'am. So I would hand over to Benga Ajala at this junction. Benga, over to you.
Thank you, Busola, and thank you everyone for the insightful presentation so far. I must particularly thank Mrs. Adekoya, Ms. Alakularo, and Mobola Kinkube. This question goes to Mobola, and I'd like you to just say a few things on what Mrs. Adekoya just said, you know, and it has to do with the motivation to merge. What were those significant moments during the process, taking into consideration the merger, so to say, of Octus Legal and AO2 Law? Mobola.
Okay, so I had mentioned while telling my story that I had a vision and I knew that I couldn't achieve it under the structure of a sole proprietor. So I knew that after the first partnership didn't work, you know, sooner than later, I would have to, invite another partner or consolidate of some sort. So for me, it's really about what you want to achieve personally or for your career or for the brand or the business. I think that would be the strongest driving force, really.
Okay, Mobola, thank you very much. Mr. Alukularo, actually, this question goes to all the panelists, but I'd like to have Mr. Alukularo's perspective first. It says, please, how can one evolve a successful legal practice which would cater for both commercial and our traditional litigation matters, minding the continued emphasis on specialization by law firms? Should the law firm choose a niche and stick to it, or diversify, thus being able to service their needs without outsourcing? So I guess this person is trying to understand how we can sort of broaden practices such that in a law firm is a one size fits all, like one-stop shop for all areas of practice.
So, I mean, it depends on your business model. You can be full service, you can be boutique, and you can be fully specialized in one specific or a couple of specific areas. It's not a one size fits all, and it depends on what works for you. Subject areas that I practice in, I specifically tell clients the moment they mention oil and gas or energy, I say, look, I don't know anything about it. However, my partner has got everything that you require. I've never pretended for one day that I do understand oil and gas law, but I don't practice it. It's just not my space. So for any business or partnership, you must know and determine the product lines that you want to sell. You don't want to be a jack of all trades, and at the same time, if it works well for you, sure, why not? You may want to be big law. I may not want to be big law. You may want to have 80, 100, 150 fee earners, or you may just want to have 10 or 5. I say some of the most successful lawyers in this country are individuals practicing law alone. Their overheads are minimal. They may work on 1, 2, 3 instructions a year, and their earning capacity is phenomenal. So you have to choose and determine the business model you want to follow.
Okay, thank you very much, sir. That was helpful. Mrs. Adekoya, would you like to share your thoughts on this?
I think Baba said it all. I don't have anything else to add.
Oh, Thank you very much. And that moves us quickly to the next question. And I'd like Mr. Arukulari to give this a shot as well. Someone says, you have spoken well on leveraging technology in the practice of law. Can you make any comments on using billing software in client management?
So billing software, as critical and as necessary as it is, helps you to manage your billing. Per hour billing is still something, even though not novel for the Nigerian market, does not necessarily work very well with your local clients. It works really well with your foreign clients. And having the software in place helps you to manage your own internal processes and expectations vis-a-vis your revenue and what you're generating, and also helps you on a transparent basis to show your client exactly what you have done and how you've delivered it. As I said earlier, I mean, I'm big on tech. It's an area of law that we actually practice in-house. It's the future. It's the future. It's the future.
Okay, thank you very much. I can see amongst every other participant that we have Mr. Wale Irokosu, and this is about jumping protocol. I ask for your forgiveness. Mr. Wale Irokosu, we recently saw your sustainability report and to see how your firm was doing. Would you like to share your thoughts on what this conversation is about? Mr. Wale Irokosu.
Thank you very much, Mr. Ajala. I think the conversation can be more profound and topical. It's very important now. When this whole pandemic came up, some of us were scared. It was as if the world was ending. You know, I've never gone through a period where there's no instruction, there's no debit note, there's no receipt of funds. It was scary. You know, I won't lie to you, I was depressed. It was as if my whole life was collapsing. You know, but like the Chinese would often say, you know, another name for crisis is opportunity. You know, so we had to dig deep and look at what this is all about. We didn't want to panic because at the end of the day, money wasn't coming in, but you have salaries to pay. And you have every right in law to lay people off because they are redundant, there's no work to do. But I'm a bit of a socialist, and I think I could take the heat more than the workers, because that's the time you have to show support for them. One of the reasons they are working for you is the fact that they don't want to take the risk of not having money at the end of the month. You are the risk taker, you are the entrepreneur, so to speak. And it brings us to the issue of restructuring, which is something that is very dear to me personally. We have two founding partners, myself and one of my friends. He has gone off to do something else. At some point, I was trying to bring in another partner at the same level as myself to share management, business development, and everything with. I wasn't too lucky. So we started considering merging with other law firms. And we have an advisory board, which is a bit novel for Nigeria. And the advisory board consists of business leaders that are not even lawyers. And their opinion was that because of cultural issues, that we should be mindful of a merger, that we're better off with a sole practitioner that we can bring in and just plug in into our system. But I started thinking about another model, which is having alliances with people or law firms, where you try to align processes. You know, we don't have offices in Abuja or Port Harcourt or Ibadan. So what we try to do is you look for law firms that you are aligned with in terms of values and competence, and try to ensure that their processes are similar to yours. And for example, Mr. Alukolara is fantastic with private equity, technology. So I can decide if I'm doing private equity or technology, My client will probably come to me because they think I'll be cheaper. And I'll definitely be way cheaper than him because he's a business, he's a leader in that field. So it's in my interest to take them to Baba Lokolaro. I'll probably make more money taking them to Baba Lokolaro than charging them myself. So there is benefit to consolidation because you'll be able to charge premium if you have a business leader in-house. That's part of the challenge that we have because you can only be the best person in so many fields. You can't be jack of all trades. So there are a lot of transactions that we do that we know that they are paying us half of what people like Baba and Mrs. Adekoya would be able to charge. So there's so much benefit in consolidation. You make more money. You tap into each other's network. Because at the end of the day, one thing I'm very big about is social capital. You know, Baba and Mrs. Adekoya will have a lot of social capital. If I'm working with them, I can plug into that. You know, without having to build it. They don't know me. Some people don't know you from Adam. You have to introduce yourself. You can cut all that off. Some people have built the relationship over a period of 40, 50 years. But like Baba mentioned, it's like a marriage. The agreement is important, but the minute you start trying to enforce agreement, you know you're on the back foot because you are spending money to enforce. It's going to take time. So if I have my way, I need someone that is going to respect their obligation without us having a look at the agreement. The agreement should be there as a reference point. You know, what did we agree? I can't remember. Can you bring it out? You know, so value is very, very important. I have a rule of thumb with people that and I tell clients as well. You are entering agreement with him. Do you know him? Have you done business with him before? Does he pay his gatemen on time? You have people that are billionaires that will not pay their gatemen because the gateman cannot do anything to them. So that sort of man, if you enter into a partnership with him, there are some people that do PP in their own practice. He's the principal partner, but he has another practice apart from the practice that you guys are running. So then, because of our culture where we don't like confrontation, you two start cutting corners. Before you know what is happening, there are about 5 law firms in the law firm. So I think the way forward, I think the virtual thing is going to be complementary. I think it's going to be like, you know, the way we have ebooks and Kindle. Some people will still read their books, their physical books, but when they are traveling and they cannot pack 3 or 4 books, you know, they would have to go with Kindle. There are some, we as lawyers, we are also somewhat counselors. Some people want to see their lawyer, you know, so they want to come to your office. They want to be able to, they want to see, they want to look you in the eye. I have one old man. He wants to come to my office. He'll read newspaper. He'll drink tea. You know, he needs to leave the house. You know, so I mean, we're all at home. I think I'm more efficient from home. But the truth of the matter is, I need to go out. You know, that experience of going out, I think the stress of working from home is also peculiar. I can be on my feet from morning to night. But when I'm working from the office, you know, someone is visiting in between meeting while I'm driving to Baba's office, I can catch my breath. But it's not the same as home. So I think what's going to happen is people are going to probably be working in shift. Like in our own office, because of COVID, one of the things that we said was, there are certain people that are vulnerable, people with asthma, people with respiratory illness. We said, you know what, stay at home, don't come. Then people that live very far away, we say, you know what, we'll pay for your Uber because we don't want you to go on public transport so that you don't go and contract COVID. But I cannot afford to pay for Uber every day. So you come twice a week. Then in the morning, you send your instructions. In the evening, I want to know what you've been able to execute out of your instructions. So the way we work is going to change. And I think consolidation will help everybody with cutting costs, like Baba mentioned. You'll be able to leverage on experience, and you'll be able to do much more, particularly if you find the right partner. And consolidation in terms of maybe you are merging, you are acquiring another law firm, requires a lot of wisdom, and it requires a lot of give and take. Like Mr. Adekoya mentioned, it requires you to also, I mean, like in a marriage, if the wife is bringing all the money in, she can't, because of that, be saying the man cannot eat. And if the man too is bringing all the money, because of that, you can't be talking to your wife anyhow at the end of the day, because there are many things that they bring. Like me, I'm not very good with sacking people. So there was a time that the family partner that is not active anymore, he was the assassin in the office. So I was like, Kazin, I want to chase that guy. So like Mr. Adekoya said, that's something he brought to the table. Then he's a man that can look someone in the eye. He was very good with negotiating. He can sit with you and tell you, look, you're, out of 100 naira, you can't get more than one. He was very good at that. He's someone that can, if he wants to open a bank account for the firm, he can summon a bank manager that he has never met before, that he has never put any money in his pocket. He will call their general line, and so we all have special skills, and we need to appreciate what other people bring to the table.
Thank you.
The approach that we are taking to growth is organic. But we would like to consolidate if the opportunity is there. I was going to send a message to Baba that I have to come and sit with him. Thank you very much.
Thank you very much. And Mr. Irokosu, you made some points, and which I'd like to receive clearance, but now from Mrs. Adekoya. You and Mr. Alukularo and also Mrs. Adekoya at some point said going into this sort of arrangement is like going into a marriage. But at the same time, if I'm right, I stand to be corrected. I remember Mrs. Adekoya saying that she doesn't visit some of her partners and whatnot because it is strictly business. And I also remember receiving advice from some senior colleagues that you have to be careful with who you go into partnership with. And one of the things you said is there are some big men, for example, billionaires in their own right, but have difficulties to honor agreements and understanding. How then are you able to balance or marry it in such a situation where you have to go into a similar arrangement, be it a merger or a partnership with someone you don't really know outside of business? Mrs. Adekoya, I'd like you to give a little bit of clarity on that.
Okay, I started by saying that it took us 5 years to get to ALEX. So over that 5-year period, we had so many lunches, so many meetings, so many discussions, looked at different people's offices, had discussions on different things. Your view about debtors, your view about paying 10% to get briefs, your views about government appointments. All those type of issues we spent time talking about before and that's why I said it wasn't those of us who started the conversation that ended up in ALEX. Having said that, and that's why I said it's like a marriage, you have a courting period. You have to decide what are your values, what exactly are you looking for? Are you all looking for the same thing? Are you all going to sleep with your head in the same direction? Because you can sleep in a bed and there's 69. So those are the type of issues. I use the analogy of we don't visit ourselves, not because we're not friends, but just to emphasize the fact that we view ALEX as a business. We didn't come into ALEX because we were friends. That was the point I was trying to make. Some of us knew ourselves before ALEX. Some of us met in the course of those discussions that ended up in ALEX. Of course, in the office, we are chatty. If we have to be, we're joking. It's just that it's business. And that was the point that I was trying to make. Not that we took a decision, don't go to his house, so don't go to our house. So that's the point I just wanted to make.
Okay, thank you very much. Mobola,
Benga, if I may just add to that.
Okay.
So I have a few partners. One of my founding partners, Babajimi Ayorinde. I mean, we're in the office Monday to Friday every week, sometimes Saturday and Sunday. Since we founded TMP, I don't think I've been to Babajimi's house up to 5 or 6 times. I'm in the office with him every day. So we're Mr. and Mrs. TMP. So when I live here, let me go and be my Mr. and Mrs. in my house. I need to go and be your Mr. and Mrs. in your house. But more fundamentally, though, it was an agreement that we had in principle from when we started, which was whatever issues we have in this business, we don't take home. It starts and it stops here. So that there's no third party, either advisory or third party influence as to how we relate with each other. Most importantly, in terms of our relationship and how long we've known each other, incidentally, we started primary school together. We were in primary school together from primary 1 to primary 6. He was head boy and I was his campaign manager. We've been friends since birth. We're also cousins. But when we prioritize our relationship, we are partners first, friends next, cousins last. Most people don't even know we're related. We don't show it.
Thank you very much. I was going to have Mobola give a shot on what you think. Mobola, are you there? Mobola?
Yes, I am.
Okay, Mobola, what would you propose in terms of amendments to the rules and laws regulating the legal practice in Nigeria vis-a-vis technological developments and advancement? What are your thoughts on that?
I mean, I initially mentioned that we find ourselves in unprecedented times, and the laws that currently govern the industry definitely is not fit for purpose. So we need to speed up those laws to embrace, the use of technology with court hearings and other things. I mean, for situations that we find ourselves now. I hope I've been able to answer that question.
Yes, please. Thank you. Mr. Irokosu, would you like to have us hear your views on this as well? Because I know you're big on law reforms and what have you.
Come again, I didn't get the question, I'm sorry.
Yeah. So we're asking about proposals as regards amendments of what we currently have as rules and laws regulating the legal practice in Nigeria vis-a-vis technological developments and advancement.
I think it's tidier if they amend, whatever needs to be amended so that they don't start setting aside decision or overturning decisions after a lot of work has gone in, and like they always say, justice delayed is justice denied. Having said that, we have to make do with what we have. We have to make progress. In the interim, I think the practice direction should serve us until they amend the law. And I think our leaders in the profession, and I think the Speaker of the House of Representatives is a lawyer as well. They can fast track, even if it's constitutional review, they can do it in a week if everybody is on the same page. That's what I think. But I also think practice generally, we don't obey the existing law as much as we do. Coincidentally, I'm on MBA disciplinary committee, and I can tell you that, at least for Lagos, one of the panels, I can tell you for my committee, we don't have any reported case for maybe more than a year now. So is that a reflection of what is happening? So judges don't want to report. We too, we don't want to report each other because we are all friends. So we can change the laws and the rules of professional ethics as much as we want. But our culture of silence is very, very is prevalent. You know, I don't know whether that one will change. So that's my view. Thank you.
Thank you very much. Kayode Adibola, I'm trying to make this as interactive as possible. And I apologize to the panelists, but we're trying to get everyone involved in this conversation. Kayode Adibola, from the regulatory point of view. Kayode, are you there?
I am indeed.
Okay, welcome, Kayode. From the regulatory point of view, I know you're a lawyer, you're in the regulatory and compliance space. What would you be looking at in terms of advising a client, a new entrant into the Nigerian market as regards the law firms to look at? And this is not trying to have you market any law firms on this platform, but for instance, I remember that one of these points on Mrs. Adekoya's slides was that there are clients that would want more but want to pay less. So taking that conversation from the view of the need for law firms to come together so they form much more solid platforms. What would your views be on this?
Sorry, Benga, I'm not clear what your question is. Please, can you just sort of rephrase?
Good. So you're in the regulatory and compliance space. A client has approached you and wants to do business in Nigeria. Definitely they would need a law firm, but there are numerous law firms presently. Now, putting that aside, what would be your expectations amongst law firms coming together to form stronger partnership? Or do you think, or would you rather suggest that we all continue in our own little corners?
Okay, I think you've asked me a couple of questions. I'm going to refrain from mentioning names of law firms that I might think are progressive, because there's also the fact that I will inevitably have some biases. But I think that in terms of consolidation, in terms of restructuring, in terms of M&A, I am of the view that one of the key factors or key drivers of sustainability in law practices is larger partnerships, larger well-structured partnerships. And I think that, I can't remember what the exact ratio is, but I believe that there's an ideal ratio of partner to associates. And so the bigger a partnership becomes, the bigger the opportunity to employ more people. And of course, it increases the capacity to deliver efficient work to clients. So I think that where people have the privilege to establish successful partnerships or to take on new partners, they should definitely do so when they found the kind of people who meet their requirements in terms of values, shared values, and ethics. I'm definitely a proponent of that, and that's definitely why I was keen to be part of this webinar.
Thank you, Kayode. Thank you very much. Moses Chinweuba wants Mr. Ikechukwu Wana to share his experience. I'm so sorry, I don't know who Mr. Wana is, but I just did a check on him and I found that he's almost our next door neighbor. So I'd like him to share his experience, Mr. Ikechukwu Wana. So nobody stops me when I'm going home later in the day. Mr. Owana, can you please share your views? Mr. Moses Chinweuba wants to hear from you. And afterwards, we'll have Mr. Dayo Kusami answer a question and then take closing remarks from all the panelists. Thank you very much.
Hello.
Please go ahead, sir.
Yes, thank you for the opportunity to participate in this very insightful webinar. I think it's not arguable that partnership is the way to go. I've listened and I've gained a lot of insights. I agree that it's like a marriage. All the parties need to cut to understand what the purpose is and what the direction they're headed to. But I think more importantly, it's important that persons who are getting into the bed find out what their values are. I repeat the word values. So what is the value with regards to money? What's the value with regards to ethics? What's the value with regards to efficiency? What's the value with regards to service delivery? It's important that those issues are clearly agreed upon before the relationship is entered into. But I think, yes, it's something that would benefit every person who is involved. And it's a decision that has to be agreed upon before, you need to agree with yourself, one, as an individual getting into partnership, and with other parties getting into the partnership before the arrangement is consummated. Those are my views.
Thank you very much.
This is a very good point, very good session, and I've learned a lot. Thank you.
Thank you. Thank you very much. Mr. Dayo Kusami, are you still there? Okay, in his absence, I would like the panelists to please, one after the other, take this question and in answering, just give their closing remarks. How would you, what would you say that the coming together of law firms to form stronger partnerships, how would you say, what would be the reflection on the overall welfare of staff? Because that's another area we need to look at. It's not just about firms coming together to become bigger and stronger. Will this in turn translate to better welfare for staff? Mobola, can you please take that and then also give us your closing remarks, please?
Sorry, can you take that question again?
Yes, we've all during this conversation agreed that it's time we begin to collaborate and look into consolidating for stronger and more effective practices. Having said that, what would be your views in terms of these partnerships, consolidations, and collaborations? How would you reflect to better welfare for staff? It's not just about coming together to have 200 lawyers or 300 lawyers in the practice, but how would you in turn take care of welfare of staff?
Okay, thank you very much, Benga. I think coming together, you'd have better structures. You put in place better welfare for your lawyers, insurance, pension, trainings, and allowances. I feel like coming together would allow you in terms of your finances to be able to give your lawyers better welfare. Yeah.
Thank you, Mobola. Thank you very much. Mr. Alukolaro, sir.
I think, Benga, you may be the best person to answer the question, and I'll tell you why. I understand you got married recently, just about a week to be precise. Before you got married, you must have met this young lady, which I'm not sure whether she's on this webinar or not, but I saw a few posts on LinkedIn that I had to repost myself, and I wondered how come she had so many, a post had been liked so many times, and was there a connection between Benga Ajala and this other Ajala lady on LinkedIn? But to come directly to where we're going, would consolidation bring about better staff welfare? It may and it may not. And what do we mean by better welfare? If we're just talking about pecuniary benefits, we also have to look at the times that we're in. Consolidation means there's more number to the people that you've got hired. You may think that you're going to share cost, but it could also increase on cost. And as such, when you consolidate, you may be taking some very difficult decisions, which, as Wale Rokosu said, he's almost a socialist, or he's a pseudo-socialist. You may be thinking about the welfare of your people and saying, I'm not going to reduce salaries. I'm not going to fire anyone. You know what? I'll take the hit and I'll take it on the chin. And I'll keep carrying these guys because they have been serving this business with me for the last how many years. And you may have a consolidating firm you're going into partnership with, which is more a more economical, a more capitalist-oriented firm that says, look, let's just go lean and get rid of all these overheads and all these people who we don't require. There may be a service area that is not very profitable at the moment. Perhaps it's oil and gas. The price of oil is so low right now, and there's not a lot of activity there. So let's let them go. Now, it could also be such that you consolidate, and because you've consolidated, you have more human resources. And as such, you can cut your people a bit more slack. You may be able to work from home better. You may be able to have a creche in your offices. And as such, your nursing mothers or mothers with younger children can bring their children in. You may be able to reduce your working hours. And you may be able to give other welfare benefits to your colleagues as against cash. You may also be able to pay better because you're more well-to-do and you're more profitable as a business. But the truth is, I really can't say to you now what consolidation would do for the welfare of an organization's staff until we actually get there and see what will happen.
Okay, thank you very much. And just before I get to Mrs. Adekoya, you're right, sir. I got married recently, but not to the other Ajala lady. This is because I need to get home tonight so that my door isn't locked before I get in. Oh, thank you very much. So, Mrs. Adekoya.
Congratulations on the wedding.
Thank you very much, ma.
Consolidation and the effect on staff. It depends. I think that it'll make competition more keen for good quality staff. And therefore, I believe that if you consolidate, you merge, you acquire, some staff will leave. Some staff will be asked to leave because they won't fit into the structure. You may not need 7 litigation clerks. You may not even need 7 litigation lawyers. You may need 5 or 4, and then be prepared to pay them more because you have access to deeper pockets. There are now 5 of you contributing to salaries instead of 1 person or 2. So it really depends on the structure that you're trying to put together. In my final closing words, what I would say to everybody is that whether you are merging, you're consolidating, or you're acquiring, please remember the words of Maya Angelou. If you think that the grass is greener on the other side, the water bill there is higher too.
Thank you very much. And I must thank everyone for the time and the words of wisdom, the experience you've brought to bear. We hope to call on you again sometime soon in a much more prepared and better format. But thank you for your time. Thank you, Mrs. Adekoya. Thank you, Mr. Olukolaro. Thank you, Mobola, and everyone else that was part of this webinar. I wish you a wonderful weekend. Thank you very much.
Thank you very much. Thanks to all.
Have a good weekend.
Thank you
Take
very
care.
much. We appreciate your time and effort. And we hope that this conversation will continue. We also hope that it will be the beginning of us kickstarting the institutionalization of our legal practice, of the legal industry in Nigeria. Thank you so much for responding to our call. Have a good evening, everyone.
Enjoy. Take care. Have a good weekend.
Bye, everyone. Thanks for the invitation.
Thank you, ma'am.
Thank you, everyone. It's been a Thank you, everybody.
Mm.